Yours truly is the Marvin Young Ed Jr. We have here Sir CASHMIR CABALO, Sir William Garado, Ma'am SHAELLA ESTEBAN, and Ma'am RAEANN SHANEIKA GOROSPE. So our group will discuss the general principles of taxation, starting with the definition of taxation, characteristics of taxation, theories in taxation, and nature of taxation. So before we begin, so we would like to define first what is taxation. It is the power by which an independent state, through its lawmaking body, raises and accumulates revenue from its inhabitants to pay the necessary expenses of the government. So taxation is defined as the power, process, and means. Power meaning it is inherent power of a state, a process because it passes the legislative undertaking through the enactment of tax laws by the Congress, which will then be implemented by the executive branch through the Bureau of Internal Revenue, and it is a means because it is a way of collecting and apportioning the cost of government among those who are privileged to enjoy its benefits. So to expound this concept through the cases, we will first call Sir CASHMIR to discuss the first case.
Okay, so thank you so much for the wonderful introduction, Sir Marvin. So the first case that was assigned on our inner group is the City of Milwaukee versus Milwaukee Suburban Transport Corporation. So this is a foreign case. So apart from what we have seen previously, most of the cases are coming from the local. So for this one, the story behind this is the City of Milwaukee undertook to repave a widened streets to accommodate trackless trolley and bear the expenses of the obligation formerly that of the company Suburban Transport to repave and maintain the track zones by adopting the conversion ordinance. So basically, ang sinasabi dito is si city, tinake over niya yung trabaho dapat ng isang contractor, that's Suburban Transport. Moreover, under the ordinance, passengers are charged 10% or rather $10 per head. On top of that, annual fees charge over 100,000. This is an additional charge for repaving and widening the streets. So may sinisingil na silang $10,000 per city to naniningil na silang $10,000 additional. On top of that, may $100,000 pa. And then with this, ang sabi ni city, the city claims that the fees exacted under the ordinance are made in the exercise of the police power. So as opposed to, because adopting conversion ordinance, it assumed expenses and inconvenience not previously borne by suburban transport. So yung exercise niya or exaction of money is based on police power and not taxation. Yun ang sabi ni city. Moreover, the city claims that the ordinance in questions are binding contract entered into between the city and the company Suburban Transport, effectively only upon acceptance of their terms by the company, and that the legislature has no power to impair the obligation. So ano ba talaga yung issue natin dito? Ang sabi dito, yung license fees through the ordinance na pinasangan ng City of Milwaukee, was it under, is it a tax or is it a regulatory act of the city? So ano bang sabi, ano bang decision ng Supreme Court dito? Ang sabi nila dito is license fees are taxes. The ordinance in questions, the fee exacted was a revenue measure rather than a tax. So sabi nga kanina ni Sir Marvin, dinefine niya kung ano yung taxation. So according to the exact terms here in this case, the term taxation defines the power by which the sovereign raises revenue to defray necessary expenses of the government. So ang nangyari dito is si city parang magtago yung through ordinance, gumawa siya ng gusto niyang i-regulate sana yung paggamit ng kalsado or yung mga pathways or paveways na ginawa nila. However, it was deemed by the Supreme Court na taxation siya or revenue measure. It's not regulatory. So basically, yun lang naman yung wisdom ng case na to. And furthermore, yung sinabi pa ng Supreme Court dito or diniscuss pa niya dito is ano ba yung purpose talaga ng taxation? Bakit siya na-impose sa mga taong ito? And then furthermore, who are those persons, or ano yung bakit nagkakaroon ng taxation, saan siya na-impose? It is imposed upon person's property or property rights as seen as in the case. So, yun ang nangyari dito. So, another thing is, just to highlight, makikita rin natin sa case dito na nagkaroon talaga ng distinction. Ang police power is for regulatory purposes. So those are license fees as answered by Sir William in one discussion. Parang naparecite si Sir William dito. Kung maalala niyo, Sir William, napatanong kayo, and then nagot niyo license fees immediately. And then another thing here is, of course, taxation. Yung taxation is more on a revenue measure. So basically, that's the wisdom of the case of the City of Milwaukee versus Milwaukee's Suburban Transport Corporation. So, Sir Marvin, I think you have the second case. Please take it away.
A very good discussion on that first case. So it was well explained, yung doctrine ng case na yon. So with regard naman to this second case, Mactan Cebu International Airport Authority versus the Honorable Ferdinand J. Marcos in his capacity as the presiding judge of the RTC 20, Cebu City. So basically, the facts of this case lang is the petitioner Mactan Cebu International Airport was created by virtue of RA 6958. So they are mandated to principally undertake the economical, efficient, and effective control, management, and supervision of the Mactan International Airport in the province of Cebu and the Lahug Airport in Cebu City. So since the time of its creation, so itong airport na to is enjoying the privilege of exemption from paying realty tax in accordance with its charter, which provides that the authority shall be exempt from realty taxes imposed by the national government or any of its political subdivision. So however, sometime the Office of the Treasurer of City of Cebu demanded payment for realty taxes on parcels of land belonging to the petitioner, which is the Mactan International Airport Authority. So, of course, the petitioner objected to such demand for payment as baseless and unjustified, claiming in its favor that, yun nga, yung sinabi ko kanina na Section 14 of RA 6958 that they are exempted from paying realty taxes. They also asserted that as an instrumentality of the government performing governmental functions, citing yung Section 133 of the Local Government Code, which puts limitation on the taxing powers of the local government units. So, yung Section 133 na yon ng Local Government Code, it provides that common limitations on the taxing powers of local government units unless otherwise provided herein. The exercise of the taxing powers of provinces, cities, municipalities, and barangays shall not extend to levy on the following. So particularly, taxes, fees, or charges of any kind on the national government, its agencies, and instrumentalities, and local government units. So with that, since yun ang claim ng Mactan Cebu International Airport, so ganun pa rin ang ginawa ng respondent city. They refused to cancel and set aside the petitioner's realty tax, insisting that si International Airport is the AGOCC whose tax exemption privilege has been withdrawn by virtue of sections 133 and 234 of the Local Government Code. So naunang nag-effect yung charter ng Mactan Cebu International Airport. Then here comes the Local Government Code nung 1991. So with that, it was expressly repealed yung exemption nila na yon. Okay? So, yun sa section 234 kasi ng Local Government Code, it provide that except as provided herein, an exemption from payment of real property tax previously granted to or presently enjoyed by all persons, whether natural or juridical, including government-owned corporations, are hereby withdrawn upon the effectivity of this code. So basically, yun yung pinaka basis why kailangan magbayad ng realty tax ng ng Mactan Cebu International Airport. So, yon. So, yung pinaka-doctrine nito is while it may be true that under its charter, the petitioner was exempt from paying its realty tax, the exemption was withdrawn by Section 234 of the Local Government Code. So, kasi nga, as a general rule, the power to tax is an incident of sovereignty and is unlimited in its range, acknowledging it in its very nature, no limits, so that security against its abuse to be found only in the responsibility of the legislature, which imposes the tax on the constituency who are to pay it. So nevertheless, effective limitations thereon may be imposed by the people through their constitution. Our constitution, for instance, provides that the rule of taxation shall be uniform and equitable, and Congress shall evolve a progressive system of taxation. So, verily, taxation is destructive power which interferes with the personal and property for the support of the government. However, tax statutes must be construed strictly against the government and liberally in favor of the taxpayer. So, basically, yun yung gustong i-point out lang sa case na to. So, on the other hand, may opposite naman ito kung yung yung Mactan Cebu International Airport ay pinagbayad ng realty tax. Yung kasunod naman na case nito, yung Philippine Health Care Providers Incorporated. This case is about the HMO, yung tinatawag natin na HMO. Most likely, marami sa atin merong ganito. Philippine Healthcare Providers Incorporated is a domestic corporation engaged in the business of providing medical services to individuals who enter into health agreements with it. So, individuals enrolled in its healthcare programs pay an annual membership fee and are entitled to various medical services provided by its duly licensed physicians, specialists, and other professional technical staff participating in the group practice health delivery system at a hospital or clinic operated or accredited by it. So, yan yung operation ng Philippine Healthcare Providers Incorporated. So, subsequently, yung CIR sent a formal demand letter and a corresponding assessment notices demanding the payment of deficiency. So, meron siyang deficiency ng payment sa kanyang documentary stamp tax year 1996 and 1997. So, yung amount nito, medyo malaki. Medyo malaki yung amount niya. So, what happened then is that the court ruled in favor of the CIR. Okay? So, PHCP protested the assessment alleging that being a health maintenance organization or HMO and not an insurance company. Okay? So, it is not liable to pay documentary stamp tax, supposedly. Ganon yung contention nila. Kasi, under the NIRC of 1997, only companies engaged in the business of fidelity bonds and other insurance policies are liable to pay documentary stamp taxes. So, the Supreme Court, in its first ruling, held that the healthcare agreement offered by PHCP in the nature of a non-life insurance, which is a contract of indemnity. So, the fact that is an HMO and not an insurance company is irrelevant. So, yun yung unang ruling nila na parang wala namang pinagkaiba yan. So, magbayad ka pa rin ng tax mo. So, the Supreme Court upheld the decisions of the Court of Appeals and the Court of Tax Appeals. However, in its motion for reconsideration, so the court reversed and set aside its previous decision. Because under section 185 of the National Internal Revenue Code of 1997, DSC is imposed only on company engaged in the business of fidelity bonds and other insurance policies. So binaligtad nila yung decision nila, yung former decision nila, previous decision nila. Because petitioner is an HMO, a service provider and not a not an insurance company. So yun yung parang pinaka naging basis ng decision ng Supreme Court to grant yung motion for reconsideration. Kasi nga, as an HMO, so healthcare agreements are clearly not within the ambit of Section 185 of the NIRC, and there was never any legislative intent to impose the same on HMOs like the petitioner. So yun nga, the same should not be arbitrarily and unjustly included in its coverage. So yun, basically yun lang yung pinagkaiba ng dalawang case na yun. So kung yung una is pinagbayad ng tax, yung pangalawa is exempted from paying its taxes. So for the fourth case, I think we will be discussing the characteristics now of taxation. To continue with the discussion, sir?
Yes, Attorney Young Ed, thank you so much, sir. And, I'm excited to see you defending a case in court, most probably at RTC Baguio. Anyway, this is greatly confirmed that when we talk about taxes being the lifeblood of the government, so it's like for income generation, and of course, based on the lifeblood doctrine, without revenue raised from taxation, the government will not be able to survive. And of course, it would be detrimental to our society. So it's like saying without taxes, the government would be paralyzed for lack of motive power to activate and operate. Just like in relation to the case of Sison versus Ancheta, this is actually a landmark case. Ang nangyari itong si Sison, he questioned the validity of Section 1 Batas Pamansa Bilang 135. Ito po yung that provides for the rates of tax on citizens. Like how much would be the tax for compensation income, net income, royalties, prices, and other winnings, including interest from bank deposits, in yield, or any other monetary benefit from deposit, and many, many more. And include also adjusted gross income. Now, si Sison, as a taxpayer, he went on to allege that it would be unduly discriminatory against, of course, to his end, to impose higher rates of tax upon his income arising from the exercise of his profession. As opposed to mga ibang may fixed income na talaga or salaried individual taxpayers. So ang sabi niya, he characterizes the above section, which is Section 1 of Batas Pamansa Bilang 135, as arbitrary. So hindi daw makatarungan, amounting to class legislation, oppressive and capricious in character. And he went on to allege that there is a transgression of the so-called equal protection and due process clauses of the Constitution, as well as a rule requiring uniformity in taxation. Pero ang argument ng Office of the Solicitor General dito, he argued that Batas Pambansa 135 is a valid exercise of the state's taxing power, and that the authorities in cases cited by the petitioner, by Sison, do not support their claims. So ang issue na dinulog po rito ng ni Sison sa korte, ang nakita po ng court po rito na whether or not the sale provision is in violation of the equal protection and due process clause of the Constitution, while also violating the rule that taxes must be uniform and equitable. Now, pumasok na rito yung korte. The Supreme Court ruled against Sison. Kawawa naman, being a taxpayer. The Supreme Court explained that the power to tax is an inherent prerogative. So meaning to say it has to be availed of to assure the performance of vital state functions. Meaning it is a source of the bulk of public funds. And taxes, going back to the lifeblood doctrine being, the government being the, there should be what we call availability being the essence. So meaning collecting taxes from people is not a violation according to the Supreme Court. But there are safety measures. Una, the Supreme Court mentioned meron silang binanggit dito na they zeroed in when it comes to the first one is due process. There should be due process. So meaning to say, like sa BIR, the computation must be submitted to the taxpayer and it must be in writing. Equal protection. So meaning to say, yung taxes ng mga negosyante as compared sa mga ordinary employees, magkaiba sila. So siyempre, mas mataas yung taxes ng mga negosyante mismo. And of course, there should be tax uniformity, meaning there should be a particular computation between compensation and taxable net income for professionals and business people. To cut the long story short, the court dismissed the petition. Ang doctrine na we are learning here is under Section 228 of the Tax Code, stating that whenever the tax authorities find that proper taxes should be assessed, they must notify the taxpayer of their findings. So meaning there should be transparency. And the notice shall be in writing and must include the law as well as the facts on which the assessment is made. And the failure to do so, the assessment shall be void. And of course, equal protection. So this is actually based on classes. May BIR has particular computations, kunyari yung taxes dito, at taxes sa isang grupo, and they must be actually the taxpayers must be informed based on their findings. And the second case naman, this case is quite exciting. The Philippine Guarantee Corporation Incorporated versus the Commissioner of Internal Revenue in the Court of Tax Appeals. Ang nangyari dito, itong Philippine Guarantee Company Incorporated, isa po siyang domestic insurance company. Tapos, it entered into a reinsurance contracts with a particular foreign insurance company. So, meaning to say, they were remitting yung mga part ng premiums nila. Kung ano yung mga risk dito, yung mga, kunyari, may mga liabilities in the Philippines at the same time, it would be shouldered partly ng foreign insurance company. Now, when they were paying their taxes, they were submitting their taxes sa gobyerno, na-check ng gobyerno mismo na may liability sila. Kasi ginawa nila sa sinabi nila computation, they did not actually include mismo yung mga binabayaran nila sa ibang bansa na foreign company. Ang sabi ng gobyerno, no, hindi pa pwede. So in conclusion, ang sabi ng korte, the court affirmed mismo in decision ng Court of Tax Appeals na ordering the Philippine Guarantee Company Incorporated to pay the withholding tax based on the ceded insurance premiums. Ang dami ito, no? For the years this is too much. For the years 1953 until 1954. So 1 year pala na hindi kasama sa BIR nila sa payment yung taxes na yung kanilang binayad mismo sa foreign company. Now, if the payment was not made within a specified period, ang sabi nito, there should be a surcharge and interest would be imposed. And the court went on to decide na based sa determination daw ng income from these premiums originated from sources kasing kita ng galing sa Pilipinas. Ang pinag-usapan, yung activities mismo ng kita ng insurance ng galing sa Pilipinas, it was not actually the place where the business was actually kung saan mismo is located. Just like in foreign company, ibang bansa siya, pero yung collection mismo ng insurance company ng Philippine Guarantee, it happened here in the Philippines. And of course, the last case, ito, quite exciting too, yung Abacada Guro Party List versus Purisima. I went on to understand sa case na to, kaya pala maraming corruption sa BIR, sorry for saying, pati sa Bureau of Customs. Kasi ito palang nagkaroon ng petition dito to stop the implementation enforcement of Republic Act 9335. Ito yung Attrition Act of 2005. It was created with a certain goal to improve the revenue generation capacity and collection efficiency of two important government agencies, namely BIR and Bureau of Customs. So, ang nakalagay dito, meron daw reward system. Pag mas maraming collection mismo, may reward system to motivate officials and employees of the BIR and BOC to surpass the revenue collection goals. Wow, parang it would entice talaga ng corruption. It would establish a system of rewards and penalties. Yan. Binigyan sila ng parang Kung mamimit nila yung goal nila ng collection, meron silang kikitain. The problem, these boards consisting high-ranking government officials from different departments, as well as representatives from rank-and-file employees and nominated officials. But this one is so surprising. Ang sabi ng korte rito, and everybody I guess would be surprised, ang pinag-usapan dito, whether or not RA 9335 violates the constitutional guarantee of equal protection by restraining the scope of its reward system to BIR and BOC officials and employees only. Ang sabi ng Supreme Court, the court began by addressing the issue of whether the case is ripe for adjudication and whether the petitioners have demonstrated a personal stake in the outcome. Ang sabi ng Supreme Court, it acknowledged the importance of resolving the constitutional issues raised ng ating petitioner. But the Supreme Court made a stress on the concepts of public office being a public trust and presumption of regularity in the performance of duties by public officers. And it noted na yung presumption daw ng regularity applying to BIR and BOC officials, employees, and the law aims to encourage their dedication to duty and loyalty to public service through incentives. And of course, the court went on to regard equal protection, saying na yung classification ng BIR and BOC is reasonable and based on substantial distinction. So meaning to say, pasok na pasok siya sa reward system mismo na sinet ng gobyerno purposely for revenue generation. And also, it satisfied the requirements of equal protection. So in summary, the court upholded yung constitutionality of RA 9335 except for some basic issues. So siguro may problema rito sa mga when it comes to implementation. And of course, the law does not violate equal protection. And no violation of separation of powers doctrine. Kasi nangyari dito, yung pag-implement pala about yung mga tax na ganyan, to have a law sa legislature muna. But when it comes to enforcement, of course, ipapasa sa executive branch of the government. And of course, in closing, the court noted the importance of the role of accountability and efficient administration, and it would always start sa legislature mismo, and of course to be received by the executive branch of the government. So yan po, Attorney Young Ed and Attorney CASHMIR, and ating discussion.
Pero tanong ko lang dun sa second case nila, sila Season versus Ancheta. Required ba na mag-withhold ng tax yung insurance company dun sa reinsurance ng premium from sa foreign companies?
And thank you, Ma'am SHAELLA, for that very excellent question. Ang sabi ng korte dito, when it comes to submission ng yung computation dapat sinabit nila mismo sa BIR na naka-include na mismo yung premiums they ceded sa foreign company. Kasi nangyari dito, hindi nila sinama sa babayaran nila. Ang sinama lang nila yung mga computations based sa sales nila dito sa Pilipinas. But yes, but the transactions between that foreign company, hindi nila isinama.
Yes, sir. Sige, sir. Thank you po, sir.
Sir Young Ed?
So yun yung ganda ng discussion sa part na yon. So to discuss further yung tinatawag nilang power to tax is an incident of sovereignty and is unlimited in its range. So yun yung unlimited power ng taxation. So to further discuss, meron ditong case about yung sa videogram. So this case is Valentin Tio doing business under the style of OMI Enterprises and the Videogram Regulatory Board. So basically yung facts lang naman nito is yung petitioner on its own behalf assails the constitutionality of PD 1987 and creating the Videogram Regulatory Board with broad powers to regulate and supervise the videogram industry. Kasi nga, it amended the National Internal Revenue Code, particularly Section 134 on videotapes. So there shall be, which provides that there shall be collected on each processed videotape cassette ready for playback regardless of length, an annual tax of 5 pesos, provided that locally manufactured or imported blank videotapes shall be subject to sales tax. So parang kaya nila inasale yung constitutionality ng PD 1987 is masyado raw harsh yung ini-impose sa kanila na tax kasi 30% yung inimpose na tax which is very harsh and oppressive, confiscatory, and syempre restraint to trade, parang mawawalan na raw sila ng kikitain.
Yes, sir.
However, yun nga, since yun nga, the power to tax is unlimited in range, so basically, meron kasing pinanggalingan bakit naging ganon. So meron yung mga intervenors na affected nung medyo naging rampant nga yung mga videotapes na yan kasi its proliferation and unregulated circulation resulted ng sharp decline in theatrical attendance by 40%. So parang it results to an estimated 450 million annually in government revenues. So parang walang natatanggap yung government na taxes dahil nga wala nang nagpupunta sa movie houses, videograms na lang sila. And on the other hand, yung mga videograms na to, nag-earn sila ng around 600 million, which is galing sa mga rentals, sales, and dispositions. So, it is not subjected to tax, thereby, ang result, depriving the government of approximately 100 million in taxes each year. Kaya nagkaroon ng gantong presidential decree, of course, to regulate and syempre, to regulate the video industry and to accumulate taxes then, which is fair according to the Supreme Court. So yun lang, ganun lang kabilis yung discussion ng case na yon. Discussing yun nga yung unlimited powers of the government to impose taxes. So for the next case.
Okay, so thank you so much, Sir Marvin. So, ang next case naman natin is more of yung sinabi nga ni Justice Holmes na the power to tax is not the power to destroy while this court seats. So basically, it will boil down to the discussion that we had. It's more of the characteristics of taxation. That taxation is comprehensive and unlimited in nature. So in the case of Antonio Rojas versus Court of Tax Appeals, diniscuss dito, or the background of this case is more of 1968 ito So basically, ito yung mga panahon na nauuso na si CARP, Comprehensive Agrarian Reform. So with this, the government encouraged landowners or landlords who own vast areas of lands na sana ipamigay ito sa mga tenants nila. So siguro it would, yung mga asokarera, generally ganyan yung mga cover na ganyan. So with that, the government encouraged yung mga landlords na ibigay o benta na yung mga lupa sa mga tenants. However, in the case of Antonio Rojas or the Rojas brothers, as they say, kasi namatay na yung mga magulang nila, yung lote nila sa Nasugbu, Batangas, which is a vast land, ang ginawa nila, since the government asked them to sell this vast lands to the tenants, pina-survey nila, and then amounting to, or they spent 300,000 back then in 1968, so 300,000 is a huge money. And then apart from that, yung price ng assessed value ng lupa is around 2 million. Now with that, ang gagawin sana ni Rojas Brothers is ibebenta sana to sa government through, of course nga, Comprehensive Agrarian Reform, and then si government i-award niya yung tenancy or yung mga land title sa mga tenants. However, in that case or during that time, short si government sa pera. So, nakakaya naman, di ba, si government, wala siyang pera. So, ang nangyari dyan, so what happened here was, instead na si government would directly pay the Rojas brothers, the Rojas brothers, ang nangyari dyan, nagkaroon ng intervention na third party. It's a financing firm, Rehab Finance Corporation to be exact. Ang ginawa nila, parang nag-advance itong si Finance Rehab Corp ng 1.5M out of the 2 million na price sana ng lupa plus 300K na price nung or cost ng survey. However, suddenly, ewan ko na lang bigla, since nagkaroon nga ng malaking amount na nabenta or na-earn yung mga brothers, kagulat-gulat na lang na may nangyaring, what do you call this, assessment with their tax assessment. So what happened there is, biglang sabi nila, uy, may mga outstanding balance kayo, may hindi kayo nabayaran na capital gains tax. So, nag-complain sila. Actually, kinonvince niyo ako, the government, kinonvince ako ng government na ibenta yung lupang ito. And then, backhandedly, suddenly, nung nakapagbenta na ako, pilang sinisingil niya ako ng capital gains tax or yung mga outstanding tax ko. So, parang nalugi yata ako doon. Nauto yata ako doon in the term of in our local terms, parang nauto siya na nagbinenta ko na yung lupa tapos biglang sisingilin niyo ako ng taxes. Kaya ang nangyari dito, kayo nga pa dapat ang parang may utang pa sa akin. So, sabi nga, in the wisdom of the Supreme Court, sabi niya dito, any abusive act in relation to the imposition of tax that leads into destruction of the natural and fundamental rights, which no free government could consistently violate, it is the duty of the judiciary to hold such act unconstitutional. So as I've said earlier, di ba, ang sabi nga ni Ma'am, the COPS or the Comprehensive Unlimited Plenary with Supreme, these are the characteristics of taxation. So as I said kanina, na as preliminaries of this case, the court, while the taxation, rather, taxation would not be, or the Constitution as a fundamental law of the land overrides any legislative act that runs counter to it. So any tax law that violates the Constitution must be declared by the court null and void. So yun nga yung discussions din natin. So medyo masalimuot yung nangyari sa mga Rojas brothers. Kumbaga naisahan sila doon. So yun ang in relation to characteristics of taxation. So that's what happened with the Rojas brothers. So medyo malungkot, pero of course, good thing we have the Supreme Court and we have the justices' wisdom. So with that, in favor sa kanila, so hindi natuloy yung payment of capital gains tax as a result of the selling of the lands to the tenants. So I think Sir William, I think you're the next person to deliver the next case.
Sir, bali, yun nga, okay naman yun. Ngayon, sir, we'll now proceed dun sa parang yung nightclub yata to. Ito ba yung may-ari ng nightclub?
Yes.
Sige.
Yeah,
Yun,
okay.
sige.
Dito na muna tayo kay iCard versus City Council of
Kapitbahay nata namin yan eh.
siya, residente siya ng City of Baguio, holder ng municipal license for the operation of a nightclub called yung El Club Monaco. He also owns a couple of automobile vehicles, yung Chevrolet, Ford, sedan. Ngayon, due to this fact, he has to pay ng national government for his nightclub, the City of Baguio for his annual license fee, registration fee for his automobile vehicles. Ngayon, ito si City of Baguio may enact na ordinances na kung saan kailangan niyang magbayad ng amusement tax ng 20 cents for every person entering a nightclub licensed to do a business in the city. And yung pangalawa is yung property tax sa motor vehicles kept and operated in the city, and that yung Last one ay yung imposing graduated license fee on every admission ticket sold by the enterprises enumerated in the said ordinance amendment. Dahil sa ordinances na to si petitioner, kailangan niyang magbayad ng amusement tax para sa nightclub niya and yung annual property tax. Ngayon, kinontain nitong si petitioner na si ICARD na yung sinabi niyo namang ordinances is unjust, ultra vires. Ngayon, present niya yung action for declaratory relief to have the said ordinance to declared na void, also for the refund ng kanyang sum which he has to pay the city under the protest. Ngayon, the issue in this case is that whether itong si City of Baguio is empowered to levy a property tax on motor and amusement tax sa nightclub. The court ruled here na si City of Baguio may not levy taxes as it pleases, but only as the legislature may specifically provide. So no specific provision in the charter of that city empowering it to levy such taxes. The absence of a similar express grant in the case of the City of Baguio is proof that the power to levy those taxes has been intentionally withheld from it. So, ano nga ba rationale nito? So, do you think itong municipal corporation walang inherent power of taxation? According to what I read, itong case na to, sabi dito, no, the court concluded na itong ang ordinance na to insofar as it provides for an amusement tax of itong 20 pesos for each person entering sa nightclub, pati ang ordinance na isa which provides for a property tax sa motor vehicle should be declared illegal and void beyond the authority of the City of Baguio to enact. It is settled here na yung municipal corporation, unlike sa sovereign state, is clothed with no inherent power of taxation. So the charter or statute must plainly show an intent to confer that power. Any doubt or ambiguity of the power must be resolved against the municipality. Hence, yung inferences, implications, deductions have no place in the interpretation of the taxing power of a municipal corporation. So, ito po yung case ni ICARD versus City Council of Baguio.
So, itanong ko lang, do you think a municipal corporation does not have an inherent power of taxation?
Yes, sir. Wala siyang inherent power of taxation. Again, this settled nga sa municipal corporation, unlike nga sa sovereign state, is clothed with no inherent power of taxation. So, any doubt or ambiguity ng power must be resolved against the municipal. Thank you, sir.
Okay. So, kaya ako siya natanong kasi parang almost same case yan dito sa Pedisloy versus the province of Benguet. So, wherein the petitioner, si Pedisloy, he is the owner, or I think the corporation is the owner of the Palm Grove Resort. So, alam niyan, sa Asin yan.
Lagi ka
Parang
doon.
may nangalisan sa Asin.
Parang lagi ka doon.
Maganda na ngayon dyan. Nakagaling ko lang last month.
Magkano ang entrance ngayon dyan, sir?
Hindi ko alam yung entrance ng day tour. Pero
May tax din ba entrance nila? May tax din.
Basta maganda na ngayon itong resort na to, itong Palm Grove. And ngayon ko lang nalaman na si Pedisloy pala yung may-ari.
May-ari. Ako din, sir.
So ito, kaya pala ganun kaganda, ayaw niyang magbayad ng tax. Okay, lang. So, to continue, Pedisloy owns the Palm Grove Resort, which is designed for recreation and which has facilities like swimming pools, a spa, and function halls. So, the Provincial Board of Benguet issued a tax ordinance. So, this is the Amusement Tax on Admission, Section 59. Paragraph 2, which provides that a tax of 10% of gross receipts from admission fees for boxing, resorts, swimming pools, bathhouses, hot springs, and tourist spots is likewise levied. So, It was Pelisloy's position that the tax ordinance imposition of 10% amusement tax on gross receipts from admission fees for resorts, swimming pools, bathhouses, hot springs, tourist spots is an ultra vires act on the part of the province of Benguet. So, nilapit niyan sa RTC but his petition for declaratory relief was unfortunately denied. So, kaya nagkaroon ng gantong petition. So, he wants to assail whether or not the Section 59 of the Provincial Tax Ordinance, otherwise known as the Benguet Revenue Code of 2005, levies the percentage tax, and whether or not the provinces are authorized to impose amusement taxes on admission fees to resorts, swimming pools, bathhouses, hot springs, tourist spots for being amusement places under the local government code. So, ulitin na naman yung doctrine na tinuro sa atin na that the power to tax is an attribute of sovereignty. And as such, inheres in the state. So, it is really inherent in the state. So, however, this is not true for provinces, cities, municipalities, and barangays as they are not the sovereign. Rather, they are mere territorial and political subdivisions of the Republic of the Philippines, as explained din a while ago sa previous case ni ICARD. So, the rule governing the taxing power of provinces, cities, municipalities, and barangays is summarized na nga kanina. So, municipal corporation, unlike a sovereign state, is clothed with no inherent power of taxation. So again, municipal corporation has no inherent power of taxation. So the charter or statute must plainly show an intent to confer that power, or the municipality cannot assume it. So the power, when granted to be, is to be construed in accordance with the strict interpretation of law. So any doubt or ambiguity arising out of the term used in granting the power must be resolved against the municipality. So yun yung pinaka-doctrine ng case na to. So to continue further, sir?
So dito po, next case is yung Film Development Council of the Philippines versus the Colon Heritage Realty Corporation. So the fact stated here na yung Cebu City nagpasa ng City Ordinance, otherwise known as yung Revised Omnibus Tax Ordinance of the City of Cebu. This ordinance require proprietors, leases, or operators of theaters, cinemas, concert halls, circuses, boxing stadia, and other places of amusement to pay amusement tax equivalent to 30% of the gross receipts of the admission fees of the Office of the City Treasurer of Cebu City. Subsequently, itong Congress nagpasa ng RA 9167 creating Film Development Council of the Philippines, or yung FDCP. Ngayon, yung Section 13 and 14 of the said law, it provided there that the amusement tax on certain graded films, which would otherwise accrue to the cities and municipalities in Metro Manila and other highly urbanized and independent component cities in the Philippines during the period that the film is exhibited, should be deducted and withheld by the proprietors, operators, or leases of theaters or cinemas and remitted to the FDCP, which shall reward the same of the producers of the graded films. So according dito kay FDCP, since yung effectivity ng RA 9167, all cities and municipalities in Metro Manila, as well as highly urbanized and independent component cities, have complied with the mandate of the said law, except Cebu City, whose stance is that it is entitled to the amusement taxes. Thus, yung prompting cinema proprietors and operators within the city to remit to them the said taxes. Consequently, FDCT sent demand letters for the unpaid taxes with surcharges to the proprietors, including yung respondents Heritage Realty Corporation and SM Prime Holdings Incorporation. As a result of the demand letters, itong si Cebu City and CHRC filed a petition of declaratory relief before the RTC, stating that the Section 13 and 14 of RA 9167 is invalid and unconstitutional. Ngayon, si SM Prime Holdings moved to intervene in the said civil case. So, ang issue kasi dito is whether pumasok kasi dito yung doctrine ng the court applied yung doctrine of operative fact, and ngayon ito yung issue. Kung yung doctrine of operative fact in relation to declaration of section 13 and 14 ng RA 9167 is invalid ba or unconstitutional. So, as a general rule, an unconstitutional act is not a law. Therefore, it confers no right and imposes no duties, and the same is inoperative. However, yung doctrine ng inoperative fact applies as an exception to this general rule. This doctrine recognizes the existence and validity of a legal provision prior to its being declared as unconstitutional, and hence legitimizes otherwise invalid acts done pursuant thereto because of considerations of practicality and fairness. So prior sa striking down of the said provisions, itong si FDCP has a right to receive the amusement taxes withheld the cinema proprietors and operators during such time. So the right to receive the amusement taxes accrued the moment the taxes were deemed payable under the provisions of the Omnibus Tax Ordinance of Cebu Cities. Again, yung doctrine here kasi is that taxes, once due, must be paid without delay to the taxing authority, as it is the lifeblood of government, and their prompt and certain availability is an imperious need. This flows from the truism that without taxes, the government would be paralyzed for lack of the motive power to activate and operate it. Hence, despite the natural reluctance to surrender part of one's hard-earned income to the taxing authorities, every person who is able to must contribute his share in the running of the government. So accordingly, yung motion ng Cebu City is denied because at that time, yung Section 13 and 14 is still operative. In respect for a presumably valid tax provision prior to its being declared unconstitutional, it must be observed. Otherwise, not only would taxpayers be emboldened to undercut the ability of the state to timely collect taxes needed for important public services based on the theoretical suppositions to their legal status. It would likewise run afoul of the principle of separation of powers, which accords law enacted by Congress the presumption of constitutionality up until they are declared otherwise by. So, next case pa po tayo. Next case is yung kay Pepsi Cola Bottling Corporation of the Philippines versus the Municipality of Tanawan, Leyte. So in this case, si Pepsi Cola has a bottling plant in the Municipality of Tanawan, Leyte. So nung bandang September 1962, the municipality approved ngayon the Ordinance number 23, which levies and collects from soft drinks producers and manufacturers a tie of 1/16 of a centavo for every bottle of soft drink quart. So the municipality also approved yung isang ordinance which levies and collects on soft drinks produced or manufactured within the territorial jurisdiction of this municipality a tax of 1 centavo on each gallon of volume capacity. Ngayon si Pepsi Cola assailed the validity of the ordinances as it alleged that they constitute double taxation in two instances. Double taxation because sabi nila, Ordinance number 27 dito covers the same subject matter and impose practically the same tax rate as with the Ordinance number 23. And that double taxation because the two ordinances impose percentage or specific taxes. Ngayon, si Pepsi Cola also questions the constitutionality nitong Republic Act 2264 which allows for the delegation of taxing powers to local government units that allowing local governments to tax companies like Pepsi Cola is confiscatory and oppressive. So the municipality assailed the governments presented by Pepsi Cola. It argued, among others, that the only ordinance na number 27 is being enforced and that the latter law is an amendment of ordinance number 23. Hence, sabi dito, wala namang double taxation. So the issue in here is that whether there is undue delegation of taxing powers or that kung meron bang double taxation. So sa first issue dito is that wala namang undue delegation. So the Constitution even allows such delegation, and the legislative powers may be delegated to local governments in respect of matters of local concerns. So by necessary implication, the legislative power to create political corporations for purposes of the local self-government carries with it the power to confer on such local governmental agencies the power to tax. So under sa Constitution, local governments are granted the autonomous authority to create their own sources of revenue and to levy taxes. So for the second issue, kung meron bang double taxation, sabi here, there is no double taxation. So the argument of the municipality is well taken. Further, kung si Pepsi Cola's assertion that the delegation of taxing power in itself constitutes double taxation cannot be merited. It must be observed that the delegating authority specifies the limitations and enumerates the taxes over which local taxation may not be exercised. The reason is that the state has exclusively reserved the same for its own prerogative. Moreover, itong double taxation in general is not forbidden by our fundamental law, unlike in other jurisdictions. Kasi double taxation becomes obnoxious only where the taxpayer is taxed twice for the benefit of the same governmental entity or the city or municipality. Wala kayo questions? Gising pa ba ang mga kasama ko?
Wala pang tanong.
Wala.
Parang walang justice, no? Once we talk about double taxation, grabe. So, ito pala, Ma'am Gorospe, yung natandaan ko minsan yung kung inalaw pala ng gobyerno yung kaso kanina, yung question ni Ma'am Esteban, yung inalaw ng gobyerno, hindi inalaw ng gobyerno na hindi mag-tax mismo yung Philippine Guarantee, yung binabayaran na premium sa ibang bansa na insurance, patay. Malaking mawawalan na pera sa gobyerno. Di ba, Ma'am Shaila?
Yes, sir. Tama yan, sir. Okay. Saan na tayo?
Okay, may last case pa tayo mga kapatid.
Diretsuhin na natin para ano.
So sa last case ko, for Honorable Executive Secretary versus kay Southwig Heavy Industries. So the facts stated here, itong si President Gloria Macapagal-Arroyo, nag-issue siya ng Executive Order 156 entitled Providing for a Comprehensive Industrial Policy and Directions for the Motor Vehicle Development Program and its implementing guidelines. So the said provision here prohibits the importation of all types of used motor vehicles in the country, including yung Subic Bay, Freeport, or the Freeport Zone, subject to a few exceptions. So consequently, may 3 separate actions for declaratory relief were filed by itong si Southwig Heavy Industries, praying that yung judgment must be rendered declaring yung Article 2, Section 3, Paragraph 1 ng EO 156 is that ito daw ay unconstitutional and illegal. So, the question here kasi is whether the respondents have the legal standing in questioning the said law. So, it is said that meron kasi petitioners argue that the respondents will not be affected by the importation ban, considering yung certificate of registration and tax exemption do not authorize them to engage in the importation and or the trading of used car. Pero yung isang issue pa here is that valid ba yung exercise ng president sa quasi-legislative power? So the court ruled here that yes, pero yung police power is inherent in a government to enact laws within constitutional limits to promote the order, safety, health, morals, and general welfare of the society. So it is lodged primarily with the legislature. By virtue of valid delegation of legislative power, it may be also exercised by the president and administrative boards, as well as yung lawmaking bodies on all municipal levels, including yung barangay. So, may requisites na naibigay for that, yung para sa president quasi-legislative power, which may be defined as the authority delegated by the lawmaking body to the administrative body to adopt the rules and regulations intended to carry out the provisions of the law and implement legislative policy, provide that it must comply with the following requisites. So sa una, yung first requisite niya, which is yung promulgation, must be authorized legislature. It is said that sa EO 156 has both constitutional and statutory basis. So sa pangalawa, it must be promulgated in accordance with the prescribed procedure. So that the order must be issued and promulgated in accordance with the prescribed procedure, and the presumption is that the said executive issuance duly complied with the procedures and limitations imposed by the law, since the respondents never questioned the procedure that paved way for the issuance of the EO 156, but instead, what they challenged was the absence of substantive due process in the issuance of the executive order. So for the third requisite, it must be within the scope of the authority given by the legislature, and that it must be reasonable. So the court find yung Article 2, Section 3, Paragraph 1 ng Executive Order is void insofar as it made applicable within the secured fence in former Subic Naval Base area, but is declared valid insofar sa pag-apply ng customs territory or the Philippines territory outside the presently secured in former Subic Naval Base area. Yun po yung last case. So, Ms. Shaila, ikaw na po.
Ako na? Or ikaw muna, Sir Kashmir?
Yes, thank you so much. I was waiting for Sir Marvin. But anyways, thank you so much. Next case would be more on, diba kanina discuss ni Sir Marvin about delegation of taxation power. With this, it's more of the exemption to the non-delegable aspect of taxation. So ito ay nagsimula sa issue ng allowance, 'di ba? Napakalaking issue. So it's more of an allowance. Now, this is between Cervantes versus Audit General. This is the case of Cervantes versus Audit General Philippines. So now, with this, ang issue kasi or the facts or the background of this case, ang nangyari si Cervantes is the manager of NAFCO. What is NAFCO? It's the National Abaca and Other Fibers Corporation. So from the word itself, it is obvious naman na GOCC siya or Government-Owned Controlled Corporation. With that, him being the manager, may mga additional compensation siyang natatanggap. So ito na yung kinakasama ng loob niya with the additional benefits that he could have received. However, may nangyari along the way. But anyways, yung board ng NAFCO nag-issue sa ng resolution na mabigyan sana siya ng additional quarterly allowance amounting to 400 pesos monthly. So back then. So that's 400 pesos back then. So napakalaki niyan noon. Ngayon parang wala na lang yan. Kumain ka lang ng McDo or anything, order ka lang ng quarter pounder, one-piece chicken, no. That's wala na, kubos na. But anyways, ang nireklamo niya along the way when he supposedly received sana yung 400 pesos na allowance niya or quarterly allowance niya, biglang na-disapprove or hindi na-disallow. So basically disallowance. It was disallowed by the Central Committee. So the Central Committee is headed by the President of the Philippines. So ang nangyari dito, paano ang presidente ay maging head ng GOCC? So with that, nabigyan kasi ng kapangyarihan si President or the President back then by virtue of RA 51. So dito, nag-create siya ng office or RA 51 which created the office that supervises the office that recommend or decide the disapproval of his allowance. So basically, ito yung Central Committee. Dinis-approve yung granting of quarterly allowance amounting to 400 pesos. So with that, sabi ni Cervantes, lugi ako dito valid naman, in-approve naman ng board ito through a resolution. So mawawalan pa ako ng 400 pesos quarterly. So sayang naman. So challenge siya yung RA 51. So sabi niya, it is unconstitutional. However, sabi nga ni Supreme Court, it is constitutional. Bakit? Sabi ng Supreme Court dito, provided na yung delegation ng taxing power or the delegation ng legislature and the taxing power, basta nilay down nila yung policy and standard how it is established by the statute, there is no undue delegation of power. So malinaw na pag nagpasa ng batas, ang gagawin nila ng executory or executive department or the one executing it, dapat nandun na lahat, wala na siyang ibang gagawin. So basically, na-set ng standards and policies. So just to give you a further background there of this case, nangyari kasi dito, apart from yung binasa yung RA 51, may EO, executive pagka-appoint ni President of the Philippines being the head of that committee, naglabas rin siya ng Executive Order 77. Yung term lang naman dito is dinisallow nila yung additional compensation. So with that, the word na additional compensation, na-cover niya yung quarterly allowance. Apart from the basic remuneration na tinatanggap dapat ng mga manager of the GOCC. So, walang mangyari doon. Walang napala si Cervantes. So, so basically, he's just receiving yung basic remuneration na amounting to 15,000 monthly. So, that's about it. Wala siyang napala na disapprove yung kanyang quarterly allowance. So basically the doctrine of the case here is the rule is that so long as the legislator lays down a policy and standard it established by statute, there is no undue delegation. So yun lang naman yung doctrine ng case ni Cervantes versus Audit General. So ma'am, please take it away.
Okay. So, we have discussed yung general principles from definition hanggang the nature of taxation, and I think we reached non-delegable. So, sa cases ko, doon naman tayo sa non-delegable, but yung exceptions is yung administrative implementation. One case here was discussed already by Sir William, yung Abacada Guro party list versus yung sila Honorable Executive. So gusto kong i-emphasize dito naman yung case ni Secretary of Finance versus Lazatin. So ito, si Lazatin, siya yung Pampanga congressman ay first district representative noon, kung saan doon sa in response kasi doon sa reports of smuggling ng petroleum and then petroleum products, they wanted to ensure the correct taxes that are to be paid and to be collected by yung BIR noon. So the petitioner here, Secretary of Finance, si Cesar Purisima, he signed RR 2-2012 na ang nakalagay doon sa RR 2-2012, he required that the payment of VAT and excise tax on the importation of all petroleum and petroleum products that are coming from abroad and will be brought into the Philippines will not be exempted from this VAT and excise tax, including the FEZ or the free port and economic zones. So dito si respondent, si Lazatin, si Congressman Lazatin, he filed for a prohibition and injunction against the petitioner here, na sabi niya, iset aside at i-annul si RR 2-2012 kasi si free port and economic zones, ano kasi sila, dapat hindi sila nai-imposan ng VAT and excise tax kasi ikinokontrabin nito yung law. Yung law kasi, si RA 7227, RA 7916, and RA 9400, na-establish kasi nila na there are certain special areas na separate custom territories. And isa dito si FEZ or si Freeport and Economic Zones. Number 1 dyan si Clark, kaya pumasok si Pampanga congressman dito. Kasi in his contention, he said that the Clark Special Economic Zone and Clark Freeport Zone has a different customs territory from the Philippine customs territory. So parang dapat exempted talaga siya sa VAT and excise tax. So ang sabi dito ng Supreme Court that under RA 9400, Clark FEZ is considered a customs territory separate and distinct from the Philippines customs territory. Thus, it is opposed to importations into and establishments in the Philippines customs territory. It enjoys special incentives, and isa dito yung inclusion na dapat tax and duty free ang importation kapag papasok sa FEZ zone ng Clark. So yun, nirule ng Supreme Court na improper yung pag-impose ng VAT and excise tax sa mga FEZ. Kaya nanalo dito si respondent. So yung doctrine dito is that goods brought into and traded within an FEZ are generally beyond the reach of national internal revenue taxes and customs duties enforced in the Philippines customs territory. This is consistent with the incentive granted to FEZs, exempting the importation itself from taxes and duties. So isa siya sa ay na-emphasize dito yung nature of taxation, that one of the exemptions to the non-delegable nature of taxation is yung administrative implementation. So next is another nature of taxation is it says that it is not a contract between the state and its citizens. So na-expound ito dun sa case ni Francia versus the IAC. So ito naman, si Francia, he is a registered owner doon sa isang lot sa Pasay. And then it was expropriated by the Republic of the Philippines noong 1977 for the sum of around 9,000 pesos. But Francia here failed to pay his real estate taxes from 1963 to 1977. basta more than 10 years. And then, so, yung city treasurer, he sold it through a public auction to satisfy the delinquency nung hindi niya pagbayad. Nung may nabayaran naman siya, pero parang last quarter, or he paid it through installments kasi pero there was still a delinquency of 2,400 pesos. Kasi he was not present, he was in Iligan City. So, in 1979, Francia received a notice of hearing for a petition for entry of a new TCT. So, at the same time, Francia also filed a complaint to annul the auction sale. He claims that his tax delinquency of 2,400 has been extinguished by legal compensation kasi nga sabi niya, may utang pa ngayong government sa kanya ng 4,000 tapos pagbabayaran niyo ako ng 2,400. Pero remember that yung lesson natin dati that the government and a taxpayer are not mutually a creditor and debtor of each other. Yun yung isa sa mga important talaga sa taxation. And so this is under Article 1278 of the Civil Code that a claim for taxes is not such a debt, demand, contract, or adjustment or judgment as is allowed to be set off. So yung contention ni Francia dito na may utang kayo sa akin, dapat na extinguish na yung pagbayad ko sa inyo. Ay yung utang nyo sa akin dapat na extinguish na. In-extinguish niya na dapat yung tax ko. So sabi ng Supreme Court dito, there is no legal basis for this contention because by legal compensation, obligations of persons who in their own right are reciprocally debtors and creditors of each other are extinguished. So yun yung sabi ng Article 1278 of the Civil Code. The tax was due to the city government while the expropriation was effected by the national government. So the amount na utang niya dapat sa government ay yung babayaran dapat sa kanya ng national government dun sa portion ng lote niya na-deposit na daw sa Philippine National Bank through yung auction sale na yun. And then the petitioner here, si Francia, he admitted that he knew about the amount that was already deposited to the bank, but he did not withdraw it. So it would not have been an easy matter actually to withdraw 2,400 pesos from the deposit so that he could pay the tax obligation para sana ma-abort yung public auction sale. So another reason for this was that he was notified before the auction sale. So he was negligent on his part. So ayun, doctrine doon is that the contract of taxation is not between the state and the citizen. Hindi kailangan na magpaalam. Hindi kailangan na anong tawag dito? Hindi kailangan na magpaalam hindi kailangan magpaalam nung collector, si government, hindi niya kailangan magpaalam sa'yo na yun yung gagawin niya as long as you were negligent on your part. Next doctrine here is ito, yung sa case ni Hilado naman versus CIR, it entails yung nature of taxation that it is not political in nature. So sa case na to, 1956 pa to, si Emilio Hilado, he is a petitioner who filed his income tax return in 1951. Medyo material yung dates kasi dito. In 1951 with a Bacolod City, where he claimed the amount of 12,000 as a deductible item kasi siya doon sa gross income niya pursuant to a circular na nirelease ng CIR. So on the basis of the said return, he paid it through monthly installments. So the last payment having been on 1953. So 2 years yung nagpass. Tapos in 1952, the Secretary of Finance, may binago na naman siya nirevoke niya yung dating circular na na-release. Tapos may bago siya na in-implement na circular na sabi niya, the losses of the property which occurred during the period of World War II from fire, storms, shipwreck or other casualty, robbery, theft are deductible in the year of actual loss of destruction of said property. So the deduction was disallowed by the CIR kasi CIR demanded 3,500 pesos as a deficiency of his income tax for the said year. So the petition filed for a reconsideration. Sabi ng CIR yung issue kasi dito, whether the internal revenue laws can be enforced during the war. Sabi ng Supreme Court, yes, it is well known that our internal revenue laws are not political in nature, and as such were continued in force during the period of enemy occupation and in effect were actually enforced by the occupation government. As a matter of fact, income tax returns were filed during that period and income tax payment were effected and considered valid and legal. Such tax laws are deemed to be the laws of the occupied territory and not of the occupying enemy. So medyo nadali si Emilio Hilado doon kahit medyo material yung date, yung the year where you kung kailan na-lose yung property mo, dapat doon din yung year na mababawasan lang siya doon sa pag-file mo ng income tax return. Hindi mo siya pwedeng i-avail after. Dapat kung kagaya nito, kapag 1951 na lose yung property, dapat 1951 mo din siyang claim doon sa ITR mo. So, yun lang yung cases ko, parang na-cover. May mga other nature of taxation pa tayo na hindi na-cover. Pero as of now, complete naman tayo.
So kung titignan nga natin, halos lahat naman na-discuss, pero talagang mostly ng cases is about the inherent power of the sovereignty, the inherent power of the state.
Yes, sir.
Diba?
Yes, sir.
At saka yung nature ng taxation that is essentially legislative in function, but subject to exemption naman yon because it can be delegated to the local government units.
Yes, sir.
Diba? Through its, of course, yung legislative branch din ng LGU. Tapos, na-discuss din doon yung taxation power that cannot be delegated, yung selection of the coverage, object and property to be taxed, nature and purposes for which taxes shall be collected. And kung mapapansin natin, yung pinaka-importanting doctrine talaga doon is yung role ng Supreme Court na laging sinasabi sa atin na the power to tax is not the power to destroy hanggat andyan yung Korte Suprema natin. Because all tax laws that violates the Constitution must be declared by the Supreme Court as null and void. So very evident naman yon sa 18 cases na diniscuss kanina. Siyempre may mga petition na nag-grant, merong mga na-deny, pero at least alam natin na Supreme Court is there to validate if there is indeed a violation of the Constitution.
Yes, sir.
So, yan lang. So, to my groupmates, thank you. Hope na umabot naman tayo sa oras.
Parang ginanahan akong magbayad ng tax. Pwede magbayad na ba ng tax bukas?
Kaya doon ko nga lang naisip na yung income tax pala, parang national government. Hindi sa
Sana nga lang we pay taxes yung magamit talaga sa maayos na paraan.
Di ba, sir, sabi naman sa military, sabi nga nila, you pay us with your taxes, we repay it with our lives.
Yeah.
I do agree na pagdating sa military talaga, ang naiba lang talaga sa politics eh.
Di ba, sir?
Pag we pay taxes, we bring them into our pockets. So, it reminds me yung necessity theory ng related sa taxation. Ito pala yung the exercise of the power to tax emanates from necessity because without taxes, government cannot really fulfill its mandate promoting yung general welfare and well-being of the people. Kaya meron tayong mga infrastructures, healthcare, at mga nakukuha natin sa gobyerno mismo, nare-receive na sa gobyerno. So, mabuhay po ang ating gobyerno, supportahan po natin. Parang election na noon.
Supportahan natin by paying tax.
Bali sir,
Yeah.
malay mo balang araw sir tayo yung nandyan.
Ayun.
Ayun.
Baguhin na lang natin.